All right, welcome back to Sunday Nation. Earlier this week, I sat down with the renowned federal judge, Victoria A. Roberts of the Eastern District of Michigan for a special Women's History Forum at the Curtis L. Ivory downtown campus of Wayne County Community College District. Judge Roberts and I had a conversation about her life and her own journey in the law, and of course talking about the contributions of women and how they shaped and influenced the judiciary, and especially in the context of an African-American woman like federal judge Victoria Roberts. More from our conversation at the Curtis L. Ivory downtown campus of Wayne County Community College District. And thank you so much, all of you, for being here. This is Women's History Month. And so we are acknowledging one of the finest women, one of the most distinguished lawyers, one of the most distinguished jurists here in the Eastern District of Michigan. The Global Conversation Speaker Series here has had, in the past, noted individuals appear on this stage. And this morning we are talking to Federal Judge Victoria Roberts. And I want to say that I do recognize that federal judges hardly give interviews, so I don't know how I was able to convince her to be on the stage here this morning. But thank you so much for being here.
Thank you very much for the invitation.
I feel like this is a reunion. The last time we were here was about 8 years ago. The push for racial diversity on the jury pool in the federal court, with yourself, Judge Dennis Page Hood, then Chief Judge Rosen, Bravo McQuay, former U.S. Attorney, I think Mariam Schiffer, who was the former Chief Defender, were all on the stage having that conversation. But to begin this discussion, how women have shaped the federal judiciary, their role, contribution, and influence through your own life story, I think perhaps a more appropriate point of departure for this conversation would be to ask you to tell us what got you into the law. Why did you go to law school?
I went to law school quite by accident, actually, Bankole. Had life gone a different way, I might have been in your seat rather than in this seat, because I aspired to be a journalist. I majored in journalism at the University of Michigan. I fully intended, I had spent my short life up to then doing a lot of writing of plays and short stories and poetry. I had spent a summer, actually 2 summers, at the Michigan Chronicle, where you were, writing short articles for that paper. So it was my dream. It was my dream to be a journalist. The fall of my senior year, which was 1972 at the University of Michigan, I talked to the head of the journalism department. I told him what I wanted to do. He said that he could help me get a position, probably. But the only offer he gave me, and I'm not diminishing it at all, was with Johnson Publications. So if all of you are familiar with Ebony and Jet and other magazines, Johnson Publishing House published those magazines. That was the only help he offered me. And I was not interested in leaving Michigan. I would have had to go to Chicago. And so I stayed here and I tried to make my way with our local papers at the time, the Detroit News and Detroit Free Press. I had an interview with the Detroit News in the fall of 1972. I brought my portfolio. I brought many of the things that I had been interested in and that I wrote about. And the editor of the Detroit News said to me, and this is a quote, "You have a great portfolio, but we just hired a Black reporter." So that was really my first exposure to that kind of blatant and direct discrimination as a Black person. It's happened again. It's happened to me because I'm a woman, but that was the first. Well, maybe it was the second, because Dr. Porter steered me only to Johnson Publication. And I didn't think about it as steering at the time. I didn't think about how he was foreclosing me as opposed to some of the other journalist students that he was helping out. So that's what I was told. And I left the Detroit News office in tears, literally in tears. I had been driven there by someone who would become my husband. We weren't even engaged then, but he was in law school. And I get in the car, I'm bawling. He's in his first year of law school at Wayne State University. I told him what happened, and he said, "You should go to law school to fight this kind of injustice." And that was the beginning. I had had a thought before then of going to law school, and I started applying, and I got in.
Quite a story. We are still in a long walk to freedom. And I think, media diversity remains a big issue to this day, especially in the national reckoning on racial justice and Black Lives Matter. But that's very instructive because, interestingly, I'm just reading. In fact, I've started reading 3 weeks ago, John Johnson's biography, Succeeding Against All Odds. But let's go to the bench. So that inspiration or that incident motivated you to go to law school. What was your reaction when it became clear in 1998, after your nomination by President Clinton, that you were going to be a federal judge?
I think that was another instance when along my entire career, which began as a lawyer in 1976, where I simply had to pinch myself because I didn't expect that anything like that would ever happen to me. My background is blue collar. My parents didn't finish high school. My mother went back and got a GED when she was in her 40s. She did domestic work. She did ironing. She did laundry for people in the neighborhood. It was not what I expected. And in fact, I probably had very few expectations about how my life would unfold because I hadn't had a lot of exposure to professional people. When I was in law school, I had attempted to get a job as an intern, a law clerk, as a law clerk. I have one of my law clerks right here, Alyssa Gordon. Hi, Alyssa. But I had tried to get a job doing what Alyssa is doing for me. I applied to federal judges in Michigan. Again, I wanted to return to Michigan. I was in Boston in law school at the time. And I got one interview. It was with Wade McCree. Many of you have probably heard that name. By then, he was on the Sixth Circuit Court of Appeals. Wade was very blue blood, Harvard Law. And he extended this interview to me because he said he was intrigued by my application, by my law school, which was Northeastern, not top 10. We didn't have grades. We had extensive written evaluations from all of the professors. And there was a year that we had to spend interning in order to graduate. So a very different setup. And Judge McCree said he was intrigued. So I have an interview with him. And at the end, he said, you're great, but he said, I usually hire from Harvard and Yale and Michigan. So I'm not going to extend an offer to you. But he made a phone call to his son-in-law, who had just started a law firm, and asked his son-in-law if he could use me. And that was how my first job began. Because after that interview with Judge McCree, I didn't have a plan. And I'm graduating from law school. I didn't know what I was going to do. So that door opened up. And I say all that to say that the experience of not being able to get a job as a law clerk because I didn't have the right credentials, I wasn't the right pedigree, I think stuck with me over my entire career. And so when the possibility of becoming a federal judge, not just a law clerk, but a federal judge opened up to me, I didn't think it was going to be possible. And I actually was not the one who pursued it. There were other people in my sphere, Judge Julian Cook for one, Judge Anna Dix Taylor for another. They were the ones who pushed my application. Judge Cook is the one who first called me and asked me if I was going to apply for one of 3 vacancies. And I told him no. And I told him this experience and said, I'm not going to get it, Judge Cook. Why would I put myself through all of that pain? And I didn't do it. An application period was open for about 3 months. I didn't submit my application. Judge Cook kept calling me. Judge Taylor called me. And finally, on the very a week before, Judge Cook actually had one of his law clerks bring me the application papers. I hadn't got them myself. And the very last day that it was due, my secretary came and said, we should do this. We should do this. And I don't know to this day how Linda and I were able to put together that kind of application that was required for that position. But it was December 31st. It was New Year's Eve. It was 1996. And I was walking my application over to Eugene Dreiker's office at 4:45 to meet that 5 o'clock deadline. So when all of it unfolded and I finally know that I am going to be a federal judge, I can't even say it was a dream come true because I never dreamt that dream. I don't think I didn't have enough to dream that dream.
It's a very fascinating story because your background, one would argue, stands disruptive to the typical pedigree, as you said. It's the counter. It's not the normal requisite and so forth. Coming from that unlikely background, I'm curious, how has that been able to influence what you do on the bench? Because yours was not the usual, background.
I think my background is more akin to the criminal defendants, particularly that we see, than the backgrounds of the judges who have the Ivy Leagues and the intact families and all of the opportunities extended to them. So I say that to say that I think that it has really helped me to empathize with a number of the people who appear in front of me because I've had, and in my family, I've had so many of the experiences that bring them in front of me to be sent to prison. So sentencing is one of the hardest things that I do. And I have a deep appreciation for our communities and how we have to immunize ourselves from criminal activity. But on the other hand, the criminals fit a profile. They fit a profile. They have the same kind of broken backgrounds. They didn't finish school. Their fathers are in prison, if they even knew their fathers. Their mothers were drug addicts. They were sexually abused. They were beaten. They can't read. I can sympathize with all of that. They have substance abuse. They have mental illness. I can sympathize with all of that. And it doesn't mean that they get a break, but it does mean that their entire person is considered in the sentencing process, as we are required to do. We are required to not just consider the crime. We're required to consider the criminal, the family the criminal comes from, the children that are going to be left behind, what happens to them, the community that they're leaving, the community they're putting a hole in. So I think that it has helped me be a better judge because of the background that I've come from.
And I wanna come into that, dig into that a little bit more, but I still want to stay with the question I asked her, because this unlikely background of yours, not the typical pedigree as you emphasized here this morning, how did you feel when you knew that as a federal judge, with a stroke of a pen, you can alter the lives of people? You can have the White House backtrack on a program. You can hold an entire state hostage based on your decision. Did you reflect on that at the time? On the significance of being, at the highest levels of the judicial?
I certainly appreciated the magnitude of the stroke of a pen of a federal judge. From having been in law school, we read cases endlessly. We read cases not only out of the districts like this district and this appeals area, but from the Supreme Court, which is the law of the land. And I knew from being in law school that the judiciary was such an important but often overlooked branch of government. I think with some of the more recent fights about who's going to get on the Supreme Court, that the impact of the Supreme Court and those decisions have become much more widely known to people. People appreciate what the Supreme Court can do. But I think that's a fairly recent development. So I knew from law school the power of that pen. I didn't think that I would ever be holding that pen and exerting that kind of power, but I certainly knew how I was going to be able to influence. And it was, it's very sobering, and makes it all the more important for us to get judges on the bench, to have judges on the bench who have integrity and who are not going to abuse that power. That power is just, it's just endless. And we have to have the right people there.
And I also think, and I want to come to your accomplishments in African-American women in the federal bench, but I think also one of the most perhaps enduring examples of the power of the judiciary is the fact that the civil rights movement, the battles that have been fought, had to be adjudicated in court, and which of course underscores the essence of the judiciary. Thurgood Marshall, Charles Hamilton Houston, and others had to go to court to plead the case of Black folk.
Absolutely. Constance Baker Motley certainly comes to mind in this Women's History Month.
Yes.
Constance Baker actually wrote the first draft of Brown versus Board of Education, that complaint, and she doesn't get credit for having done that. Yeah. Thurgood Marshall gets all the credit. Yeah. Constance Baker Motley argued 10 cases in the United States Supreme Court before she was appointed to the federal bench by Lyndon Johnson. She won 9 of those cases. She represented James Meredith, who was trying to get into the University of Mississippi. That was one of her cases. And I read a biography about her as well. And one of the things she said was that in the civil rights movement, which was dominated by Black men, they sent her and they sent other women to the South because they thought they had less of a chance of being harmed. So the women were put on the forefront to go into the South and, engage in those skirmishes on the ground. Right. She even went to, I believe, Atlanta and represented Dr. King. Dr. King.
Yeah, King was a client of hers.
Exactly. So Constance Baker Motley, as well as so many other women, were on the ground and were doing that work, that kind of legwork, back and laying the groundwork for people like me. I think Justice Ketanji Jackson said that Constance Baker Motley was the role model that she looked up to. Constance Baker knew when she was 15 that she wanted to be a lawyer. I think Ketanji Jackson knew at a young age she wanted to be a lawyer. Our Stephanie Dawkins Davis, who just went up to the Sixth Circuit Court of Appeals, knew when she was a kid that she wanted to be a lawyer. I wasn't in their camp. Those are all great women, but they were focused. They are great women, and they were focused and knew exactly what they wanted to do and did it.
So I looked at the numbers in writing my Detroit News column about you. I looked at the numbers, and you shared some of that with me about the number of Black federal judges around the country. 11%, and 38% of those are women, Black women. So, and you're part of that 38%. Let's talk about what you see as some of perhaps your most instructive moments on the federal bench here in the Eastern District.
I think that in this age when we're talking about diversity and people are trying to minimize the need for diversity and equity and inclusion, I think one of my most instructive moments has been just interacting with the judges who do come from backgrounds that are incredibly different from mine. And the kinds of interactions that we have had that have been able to influence the thinking of everybody in the room. A good example of that is we have something called the Sentencing Council, and 3 judges will gather after having read the sentencing papers for all 3 of those judges and make some recommendations. One judge might be at the top of the guidelines. Another judge might be at the bottom of the guidelines. Somebody else might be in the middle. But it is those kinds of discussions that help influence the outcome. On the district court, judges work solo. Court of Appeals, it has to be a majority. Supreme Court, it has to be a majority. So on my bench, it's not as important to have those discussions that will influence the thinking of others, but they're so critical. They're so critical. So I think that just appreciating the importance of that kind of interaction has influenced much of what I have done on the bench. Another moment for me has been just realizing the importance of pro se people who are in courts, who don't have a lawyer, who can't get a lawyer. And that is a pretty high percentage of people who come into federal court who think that they can represent themselves. And as a result of that, I got our court to agree to begin a pro se clinic. We do that now in conjunction with the University of Detroit Mercy. There's a professor there who mans that clinic. Students man that clinic. It's housed at the federal court. And so now we are engaged in providing not nearly as much as we need, but providing services for people who are unrepresented in court. We've done that. Thank you. We've done that on the criminal side for a long time. We've said criminal defendants have an absolute right to be represented by a lawyer. That hasn't happened on the civil side, but things like our pro se clinic get us there, to having people have that kind of representation so that they can maneuver the very complicated court system. So those are two things, I think. The jury issue that you talked about, we are very interested in diversity within the ranks of judges, but we're also interested in diversity in the ranks of jurors. And when you understand the importance of that, then you understand why the bench needs to be diverse as well. Any lawyers in this room will know, who's done a jury selection, knows that they are going through person after person after person to get the right person on that jury, to get the right mix of people who can come together and make a unanimous decision. And so examining why I would be on the bench and I have 60 people coming through the back door for jury service and not one of those faces is Black was very disconcerting to me. And that's why Judge Hood and I began that committee to look at what was going on jury service.
And how has it been with the jury diversification?
Well, we're seeing some improvement, not nearly the kind of improvement that would make our jurors representative of the Eastern District of Michigan population, but we're seeing other minorities coming in as well. When we decided to examine this issue, it was after the court had been sued several times, and people were saying that the court was engaging in systemic discrimination to keep Blacks off the jury. And Judge Cook had one of those cases, had tried to put a fix in place. That fix was struck down by the Sixth Circuit. I had one of those cases. I looked at all the evidence and decided that there wasn't evidence of systemic discrimination, but there certainly were things we needed to do to make our juries more diverse. And that's when Judge Hood and I asked that committee be formed, and we started examining it. What we found out was that in the Black community, primarily in Detroit, summonses were being delivered and being thrown in the wastebasket. They just weren't being responded to. We also know the big problem of blight in this city. And so summonses were being delivered to homes that didn't even exist. And they were just, on the ground. So it was things like that rather than something systemic that we were doing.
Right.
And we found out that jury service in large part is an education process. And we took our dog and pony show on the road here and to a lot of other places just to emphasize the importance of jury service and to convince people how important it is. People come into court kicking and screaming. They're trying to get off of juries all the time. And I will say that at the very beginning. I know the stories. Don't make up anything to me. We're going to see through it. We're going to come after you if you've told me something. And so I think getting that kind of speech from me in the very beginning has prevented people from trying to get off. And invariably, when we conduct interviews post-trial, everyone is heartened. They feel that they've made a contribution, and they've come together with strangers and made a unanimous decision. It's quite remarkable.